I am writing you this letter to inform your party that I am invoking Article 52 of the Constitution Act of Canada against your bylaw and enactment, which you are drawing your powers to regulate me from. I am claiming my right as protected under Section 52 of the Constitution Act of Canada to avail myself of any apparent obligation to these enactments, and am declaring that this enactment is of no force or effect against me for the legal reasons indicated below. Your party is violating my constitutionally protected rights by using this enactment to designate me a class of person who subsequently owes an obligation to the enactment. I am not resident in your municipality, as defined in your statutory instruments. I do not accept to play the role of an incorporated inhabitant into this residency. When you look into the Ontario Municipal Act, it states municipality means a geographic area whose inhabitants are incorporated. Or municipality, again, in this act, a reference to municipality is a reference to its geographical area or to the municipal corporation as to the context requires. And Article 4 says the inhabitants of every municipality are incorporated as a body corporate. The operations of law that your party is using against me to declare that I am resident in this corporation is violating my fundamental rights and freedoms. If you continue to declare that I must be incorporated and have residence in your corporation, I will file a constitutional questions challenge against your position against the color of law you are using. So we just looked at above here in their statutory instruments, in their enactments, how they are saying that the inhabitants are incorporated and that a municipality is a corporate body and that we have been, as inhabitants, incorporated into this corporate body. So they are forcing us to play the role of a class of person under their enactments, incorporated into their body corporate. Now, if McDonald's or Kentucky Fried Chicken, if the owner of the restaurant knocked upon your door today, and when you opened it, he said to you, "Hey, you, listen, you're going to come to my restaurant and you're going to work for me right now, and I'm not going to pay you, and you're going to be part of my corporate body, and you have no choice. You're going to do it." What would you tell him? You tell him take a hike, right? You're not going to go there and be part of his corporate body because he wants you to be part of his corporate body. Well, this is the same thing that your local municipalities are doing to you. They are incorporating you, making you part of their body corporate, and they are not even giving you a choice. They are just doing it. Now, I am not to be considered part of the federal provincial juristic unit that is in operation. Remember, the Supreme Court of Canada explained to us what the definition of Canada means. He said in section 91.1 that the word Canada is, in section 91.1, does not refer to Canada as a geographical unit, but refers to the juristic federal unit. So here, the artificial person or the body corporate. It's the same thing that we see in the provincial enactments. Same thing. It's a body corporate, artificial person. And they're saying we have to be part of this body corporate. But we don't. It's ridiculous. I am not resident, nor do I wish to take recognition as such, as defined in your enactments, which you are using to try and force me to pay this account statement, this corporate statement. Now, Thompson versus the Minister of National Revenue stated on page 220 that residents are taxed, not Canadian citizens, but residents within the meaning of the Act. So when they send you the tax account and they're asking you to pay that tax account statement, behind that is the fact that they are declaring that you are incorporated into the municipality. And that's the mechanism or the operation of law that they are using to try and force you to make that payment. They're trying to hold you to the statutory instrument. They're trying to hold you to the enactment. You cannot use these statutory instruments to justify your actions in violating my fundamental rights and freedoms, as guaranteed in the Constitution Act of Canada 1982 and the International Bill on Human Rights. In Zinger versus the Queen, it states that the ministers, agencies, and administrative tribunals, including the municipalities, would have to be able to justify their actions by pointing to specific legislative authorities in the same way that any citizen would have to be prepared to show that his or her acts were lawful. It is a recognized principle of international customary law that a state, the municipality, may not invoke the provisions of its internal law as justification for failure to perform its international obligations. My fundamental rights as enumerated below are being violated through your actions and the interactions with me concerning this tax account. You are seeking to render me into the designation of a class of person, incorporated, resident in the local municipality. These actions are a violation of your obligation to respect my fundamental choices to exercise my rights. In the International Covenant on Civil and Political Rights, it states in Article 8.2, no one shall be held in servitude. Yet you are trying to force me to obey the statute, the regulation, by deeming me to be resident in your corporation. In the International Covenant on Civil and Political Rights, Article 16, it says everyone has the right to recognition everywhere as a person before the law. You are forcing me to take recognition as a class of person in order to administrate the enactment. In the International Covenant on Civil and Political Rights, Article 22, it says everyone shall have the right to freedom of association, and you are forcing me into an association through incorporation. Now, in the Supreme Court of Canada, DeVito versus Canada, in Article 22, it states that Canada's international obligations and relevant principles of international law are also instructive in defining the right. The content of Canada's international human rights obligations is, in my view, an important indica of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that is afforded by similar provisions in international human rights documents which Canada has ratified. All of my rights which you are violating are guaranteed and protected in the Constitution Act of Canada 1982. In the Constitution Act of Canada 1982, Article 7, it says everyone has the right to life, liberty, and security of the person. When we look at the Supreme Court judgment, S.S. Thompson Newspaper Limited versus Canada at page 1004, you find everyone has the right to life, liberty, and security of the person serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. The principles of justice that your party is using to force me to pay a security instrument is contrary to public order, and I will challenge your actions and seek damages for the tort you are creating against my natural rights unless you stop interfering with me by trying to force me to take recognition under the enactment so that you may force a contribution, a taxation from me. So they are trying to use their public laws, their enactments and regulations, what we looked at, where you are incorporated into the corporate body, to say that you owe an obligation to pay a taxation for your property. However, to force you into recognition as an incorporated individual in their corporate body, it breaches your international rights in Article 8.2 and Article 16. And it also breaches your rights under the Constitution Act of Article 7. In that video that's circling around on YouTube and on Facebook concerning that man named Dean who went before his city council and tried to defend against the fact that he was being taxed, they were responding to him. They were saying that according to the enactments, the municipal enactments, the local government enactments, we have the power to do what we're doing to you. And no, they don't. They're not speaking the truth. Yes, they have power through those enactments. They have public prescriptive law, but since 1982, things have changed here in Canada. Your public prescriptive law that you are using to incorporate that man Dean into the local municipality is beneath his fundamental rights and freedoms. His rights, his full legal capacity as an individual, it trumps your enactments and your regulations. You are not allowed to take actions aimed at the destruction of his fundamental rights and freedoms. And if you use your enactments and regulations to take actions aimed at the destruction of his rights and freedoms, then Your enactments are of no force or effect against him. Your enactments are trying to incorporate him into your corporate body. You are trying to say that he is forced to be recognized as a class of person. That is directly against Article 16 of the International Covenant and directly against Article 7 of the Constitution Act of Canada. You are saying that he is forced to obey your enactment through being designated that class of person. That is a breach of Article 8.2 of the Covenant. You are trying to hold him in servitude to your arbitrary power. That is a breach of Article 7 of the Constitution Act of Canada. The council's position, the mayor and the municipality, they want to believe and they want to stand on the fact that public law overrides our fundamental rights and freedoms as individual men and women. But this is not the truth, and this is not the case. This is the opposite to what is transpiring here within the legal world. When you look at R versus Haynes, the judgment from 1999, it says prior to the Charter's advent, before the Constitution Act of Canada 1982, the individual, like you and me, really had no special means of protecting against incursions upon his or her basic fundamental rights by the executive or legislative arm of the government. There were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. Now, apart from these exceptions, the individual's means of challenging incursions on fundamental rights were extrajudicial and of a precatory nature, meaning not very powerful or had not much force, that were neither effective nor potent. And the rule of law was this. So prior to the Charter, this was the rule of law, that Constitution hinges the existence of public order, and it mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. So prior to the Charter of 1982, bringing in the international law into Canada, law said that the primary reason for it was for public order. And if an individual was to submit his fundamental rights and freedoms to public order, this was expected. You did not have the ability to stand up and say, my individual rights and freedoms trump or are more important than the public order. Now, since the Charter, this has changed. For a primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. So again, the municipality is saying, you, sir, you are incorporated into the local body corporate, and as such, we have the power to regulate you and control you. You are now recognized as a class of person, and we are applying our bylaws against you. McDonald's and Kentucky Fried Chicken cannot come and force you to incorporate and force you to be part of their corporation. Neither can your local municipal council. By doing this to you, they are violating the international law in Article 8.2 and Article 16 and Article 22. They are violating the Constitution Act of Canada, Article 7. They are forcing you into recognition as a class of person and are trying to apply their enactment against you. This is contrary to our constitutional rights, and therefore we can invoke Section 52 of the Constitution Act and say your enactment is of no force or effect against me because you're violating my fundamental rights and freedoms. You're not granting me the choice to decide, will I play a class of persons? Will I become part of your corporation willfully? No, you are forcing me to, and you cannot do that. You are violating my individual rights and freedoms. It is in your power to produce a remedy for me concerning this situation. Even if you are unfamiliar with the mechanisms, your party does indeed have the statutory power to exempt my property. This is the remedy that I am requesting and is the only remedy I will accept. If you proceed under your statutory authority, it will be without color of right or law, and this notification will be used as evidence to my communications with your party. I think that I have expressed my grounds clearly, and that you will have no standing to justify why you continue to try and apply your enactment against me contrary to prescriptive law. If you fail to honor my guaranteed constitutional rights, as enumerated in this notification, I will be forced to seek the administration of justice against your party through the inherent jurisdiction of the court system. In case your party would be seeking to have me enter into a statutory court so that you could apply your enactments against me. However, I am very aware of the court systems, and I will bring your party to a proper court of law to access the inherent jurisdiction of the court. In Corolla versus Minister of National Revenue, 2002, the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to the jurisdictional basis upon which a court is asked to make a particular order. The inherent jurisdiction of a superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. This is where the power to rule on our behalf concerning our common law rights abides and is, and we can access it. Scarola versus the Minister of National Revenue, the court, as a statutory creation, does not have inherent jurisdiction. So their party, the municipality, would love to bring you into a court that is a statutory creation. They would love to force you to come to the court where the judge is only enforcing enactments and regulations. But you have the ability to drag the municipality into a superior court of record and access the inherent jurisdiction of the court. And in the inherent jurisdiction of the court, you show the court that the municipality is violating the principles of fundamental justice. Why? Because you as an individual have certain rights in this situation. You have the right not to enter into recognition as a legal person to be forced. You have the right not to be held in servitude. You have the right to association. These rights come out in the Constitution Act, Article 7 of 1982. However, the city and their council are limiting and abridging these rights by forcing you to take recognition as a class of person and forcing you to have a duty to the enactment. And by forcing you to take duties to the enactments, they're limiting and abridging your fundamental rights and freedoms. I do not foresee this matter ever having to come to the point of an adjudication. It is very clear from the many Supreme Court judgments, not included in this notification, go do your own research, that your party has the express authority to honor my charter rights when or should the need ever arise. If your party continues to try and force me to perform obligations and duties that you are drawing out from the enactments from your statutory instrument, you are without standing and grounds. Again, remember Zinger versus the Queen. It says if you're going to do this to me, you better make sure that you have a justification. You better make sure you have a legal ground and a legal reasoning to be doing this to me, because it is a recognized principle of international customary law that a state, you municipality, you may not invoke your bylaws, your provisions of your internal law as a justification for failure to perform your international obligations, for your failure to perform your charter obligations, to respect my charter rights. I'm not seeking to be arrogant or belligerent. Don't get me wrong. That's not what I'm seeking to do with your party. Neither I'm seeking to have to take this matter into adjudication. I'm seeking to clearly express my position to your party in order that you honor your obligation to me as one individual with fundamental rights and freedoms. I am being forced to take this matter under consideration as a legal matter, for my legal rights are being limited and abridged contrary to the principle of justice by your actions. The abridgment and limitation of my rights by your party is producing a prejudice against me concerning my personal property, and I do intend to pursue this matter if your party fails to act accordingly as required for Section 52 of the Constitution Act of Canada. They're taking the funds away from you. They're forcing you to pay a tax account as a class of person, and this is damaging to many. Their house value has risen a great deal over the past 4 or 5 or 6 years because of what's been happening in the housing markets. And as the house price has risen, so has the tax bills risen to a point where men and women cannot even afford their tax bills anymore because they are so high. Well, they are only using a mechanism in law, an operation of law, that is classifying you as a class of person in order to remove your legal capacity and strip you of your individual rights, but your individual rights protect you against what they're doing. And if you understood and know what they're doing, you can fight back against them. Again, they are coming to you and they are saying, you, sir, you, ma'am, you are incorporated. You are incorporated into the body corporate. And as such, I am your manager. As such, I am in control over you. I have administrative rights over you. Your property is being taxed through this operation of law. They're sending you the bill and declaring you are an incorporated individual or person in the body corporate. That's what they're doing to you. But by doing that to you, they're stripping you. They're removing your natural fundamental right that says you cannot be forced to take recognition as a class of person. You can choose to, but you cannot be forced. And you want an example? Look at the right to vote. We have been granted, the citizen has been granted the right to vote. So you're a man, you're sitting at home. You're eating supper. Or you're a woman, you're sitting at home. You're eating supper. It's voting time. You finish your dinner, you get up, you put your coat on, and you're about to go and vote. Well, you're entering into a class of person that is called the Canadian citizen in order to exercise your vote. If you are considered a permanent resident in Canada, you cannot cast a vote. That class of person does not have the ability to cast a vote. It's only the class of person that is the citizen that has been granted the right to cast a vote. So you're getting up from your natural capacity and you're entering into recognition as a class of person, the citizen, willfully to go and cast the vote. This is not what is transpiring with taxation. They are forcing you, they are making you enter into recognition as a class of person, incorporated into their body corporate through their enactment, and they are breaching your fundamental right. They are not allowing you to choose, and they are subsequently saying you have to serve this enactment. Whatever we are requiring of you, whatever duty and responsibility we are drawing out of the enactment, you have to perform it. This is a breach of your individual rights and freedoms. And prior to the charter, yes, they could do this to us. Prior to the charter, public law said, we mandate your compliance. We mandate that you have to submit. However, since the charter, it's different. Our fundamental rights and freedoms overrule their enactments and regulations. And if their enactments and regulations are limiting or abridging our fundamental rights and freedoms as guaranteed, listen to that word, guaranteed to us through the charter and through international law, well, they are of no force or effect, and they need to be challenged.